It does seem to me that your argument is essentially that what the Appropriations Clause demands is annual line item appropriations, that's the not just the paradigm appropriation, but the only constitutionally valid kind of appropriations, and that any deviation from that needs some special justification, or maybe is just like unconstitutional per se. I'm not exactly sure what the argument is. But the history of our country just rejects that scheme. I mean, that might have been a way to understand what the framers were doing. But it turns out that from the very first year, that's not what they were doing. That's not what they did. Annual line item appropriations were some appropriations, but massively not all appropriations. And so you're just flying in the face of 250 years of history.
And respectfully, Your Honor, that's not my argument. I think that the lack of durational limits here is what makes this particularly problematic, but it's particularly problematic when you combine that with a delegation to an executive branch agency to pick its own appropriation, subject only to a limit that's so high it's almost never relevant. If you can do that here, you can go agency by agency by agency and simply say, spend whatever you think reasonably appropriate as long as you don't hit $10 billion. And while
I'm sorry, I'm trying to understand your argument and I'm a total loss.
I'll try to do that.
Okay, I think I understand it the way Justice Kagan does, but you're telling me it's something different. From the very beginning, Congress gave sometimes a lump sum and said to an agency, you can spend this amount, but didn't do a line by line on what or how much, and the agency would decide how much of that sum it needed. Over 60% of the appropriations, I think it may be 73, 63, something like that, are of standing appropriations. They're not given every year. And some of them are fixed and some of them are not. Some are, whatever you need to run your agency, including from the very beginning in 1789, the Customs Service. So I don't understand what you're saying.
So Your Honor, respect that.
Unless you're saying standing appropriations are wrong, tell me why they're wrong. If they're not wrong, tell me when they're right. Tell me how much detail they have to go into. And why is a cap different than a standing appropriation for a certain amount, since we can't force anybody to spend as much money as you give? And routinely, lots of agencies return money, including this one, the court. So either, I don't know what you want.
So the first thing, Your Honor, is I would like to address the Customs Service, because my understanding of it is not the same as my friend's understanding of it. As I understood the Customs Service at the time of the founding, it was actually funded through fees that it collected as part of the collection of customs, and Congress set those formulas. Congress determined what fees they could collect or what formula they could use to collect those fees, and in addition, it was supervised by the Department of the Treasury, which was itself subject to annual appropriation. So I don't think it was a standing appropriation. Now, it was a standing appropriation between 1849 and 1912. There was a $1.5 million standing appropriation, but two things about that. It was still subject to the supervision of the Secretary of the Treasury, and that turned out not to be enough. They had to generally go back for regular appropriations. Now, that's at least how I understand the history of the Customs Service. In terms of what the standard is, I think our frontline rule is at a minimum Congress has to determine the amount. And the reason I'm focusing on the factors that I'm focusing on is because when you bring those factors together, you have really exploded any limitation at all. And I think it's enough to say that when you delegate to the executive the authority to pick its own number subject only to a cap that's so high it's rarely relevant, and if not perpetually, at least for a long period of time, you have uniquely brought together a set of factors that does allow Congress to essentially transfer its appropriations power to the executive branch for an indefinite period of time, and you just have to multiply that across the agencies to see why that's so dangerous.
It sure seems that, on your view, the Federal Reserve would also be unconstitutional. Why or why not?
No, Your Honor, for a couple of reasons. I think the main one is that, as this court has suggested in Seal of Law, and as I think then Judge Kavanaugh suggested on the D.C. Circuit, the Federal Reserve is pretty much sui generis. I think it reflects the fact that at the time of the founding, the core functions of the Fed, controlling the money supply through open market transactions, weren't really considered governmental functions at all. That's why.
So there's also a governmental function component
Well,
of
no,
your
Your
test?
Honor. I mean, if
because you
it's not-
state a test and then a agency that clearly fails under that test, you say, oh, no, I don't mean
No,
that.
because for the Fed, remember, the first and second national banks were organized as private banks. To this day, the presidents of the private regional reserve banks sit on the Federal Open Markets Committee. And it's also why I think that if this court were ever to take the step of overturning Humphrey's executor, it likely wouldn't impact the for-cause removal restrictions on the board itself. And I think it does reflect that historical tradition in the Fed of it not really exercising governmental power.
Yeah, it's just too important and whatever. I mean, the FDIC, the OCC, they also fail your test.
No, the FDIC, and the OCC, I think, are well within the tradition of agencies that are limited to what they can collect from the people that they serve and regulate. But I think my more important point, Your Honor, is if you think
you're now adding a new thing to your
No,
test.
I'm not, Your Honor. What I'm saying is that if you think that those serve as the model for the CFPB, then it really is Katie bar the door. As my friend explained, those agencies don't even have a statutory cap. So if you think that that's what justifies the CFPB, then you truly could go agency by agency and simply say, spend whatever you want, full stop, period. We'll come back to you when we think we can override.
What's the
difference